Good afternoon, everyone, and thank you for joining me for Secrest Wardle's January 2018 version of the Michigan PIP Monthly. My name is Javon David, and I am an attorney at Secrest Wardle's Troy location. We decided to do these podcasts to give our clients and our audience really an opportunity to, stay on top of the law and learn about recent updates in case law while on the go. So you can play this podcast as you likely are doing now during your lunch hour or while driving in the car, or just if you have some downtime, you can listen to us and stay on top of the law for the monthly updates that come out. And we follow the Michigan Court of Appeals, the Michigan Supreme Court, and we monitor topics that are trending in the legislature as well as in the general field of no-fault litigation. We'll provide you with an overview of what's kind of gone on, what the landscape of the no-fault realm is, but mostly focused on some key cases that will affect claims handling and claims management, as well as the litigation phase of your cases. So the last 30 days or so, there were some seminal cases that came out, but what is most important is the Bazzi case, Bazzi versus Sentinel, that was finally heard before the Michigan Supreme Court on January 11th, 2018. Now, Secrest Wardle successfully handled the defense of that case involving fraud in the application for insurance. And essentially what Bazzi held is that if an insurer is entitled to rescind a no-fault insurance policy based upon a claim of fraud, it is not obligated to pay benefits under that policy, even to a third party that may have been innocent to the fraud. Now, a lot of times, if you file, a Bazzi motion or a motion indicating that there was some sort of material misrepresentation, thereby warranting an entire rescission of the policy, you'll get a response from opposing counsel, or even at the claim stage, you'll get a letter saying, well, my client wasn't part of the fraud, or my client had nothing to do with the application, but they are still entitled to receive benefits under the policy. Now, what Bazzi did is allowed us to say it doesn't matter. The insurance carrier is not going to be held responsible for payment of any benefits if they were defrauded into issuing the policy in the first place. And since Bazzi has come out, and since the case that Bazzi relied upon, Titan, came out, we've all been successful in handling these cases and refuting these claims. Now, can the Michigan Supreme Court affirm the Court of Appeals in Bazzi? Absolutely. And then it will be business as usual with responding to those kinds of arguments. But we'll have to wait and see what they do. So essentially, we watched the oral arguments before the Michigan Supreme Court, and essentially, the court listened to both arguments from both sides and seemed to have a particular focus on a few things. So the principal arguments made by plaintiff before the court was that the Court of Appeals erred when it held that Titan was controlling in a first-party case. Indeed, Titan was a matter involving a third-party action and held that an insurer is not precluded from availing itself to traditional legal and equitable remedies to avoid liability under an insurance policy on the ground of fraud in the application for insurance, even when the fraud was easily ascertainable. And Bazzi essentially extended that ruling to first-party cases. Plaintiff tried to distinguish Titan from Bazzi by pointing out that Titan involved optional coverage rather than mandatory coverage. This distinction may have been recognized by the Chief Justice when he posed a question to the defendant, noting that Titan might not be helpful because it addressed optional benefits. So the Chief Justice, at least, was focused on some of the plaintiff's arguments and really pressed the defendants on those points. And the plaintiff also argued and urged the court to focus on the language of the No-Fault Act, which plaintiff contends provides absolutely no support for rescission of an insurance policy for fraud. Plaintiff noted that the court in Titan held common law and equitable defenses apply to insurance policies unless a statute exists to limit their application. And essentially, plaintiff thereafter argued that The No-Fault Act was the statutory limit that Titan referred to, and the fact that it is silent on the issue means that it was considered by the legislature and ultimately rejected. Defendant, in response, outlined 4 arguments in support of affirming the Court of Appeals decision. First, defendant argued that an insurance policy is a contract and that equitable and common law defenses provide insurers the right to rescind a policy due to fraud in its inception. Second, defendant argued that the court did not need to balance the equities in the situation because the insurance policy was void ab initio, meaning it did not exist, and therefore it should be treated as though it never even existed. Third, defendant urged the holding that the innocent third-party rule did not survive Titan comports with legislative intent under the statute because the No-Fault Act allows for PIP benefits to be obtained through other means, primarily the Michigan Assigned Claims Plan. Indeed, the Michigan Assigned Claims Plan works to disincentivize fraud by making this the remedy for recovery. Defendant also argued that finding the innocent party rule still applied would work against the MACP. And finally, in a policy argument, defendant asserted that a reversal of Bazzi would seriously unsettle Michigan contract jurisprudence. The court listened to the arguments and seemed to focus on 3 main issues. First, and primarily to plaintiff, the court seemed interested in how to weigh the innocence of the respective parties. Obviously, rescinding a policy void ab initio would prejudice and cause arguably an unfair result to those not involved in the fraud and still seeking benefits. The court noted that under the traditional common law test of innocence, the insurance company would lose, but that this was not a typical case. In this case, the Chief Justice noted that the insurance company would be the more innocent party, and plaintiff responded to this by pointing out that when the court weighs the balances, it is employing an equitable remedy and fairness principles are persuasive. The court also seemed to ask a lot of questions about the Michigan Assigned Claims Plan, which is the insurer of last resort. And the court inquired as to what exactly an innocent injured passenger was to do if the insurance company was not required to pay benefits. Defendant repeatedly argued that the MACP would be the proper remedy in that case. Justice McCormick and Justice Bernstein were very receptive to that point and seemed most concerned that the injured party could be left to the MACP without any recourse for recovery after 1 year. The justices even went so far to say that could there be an argument as to whether or not a ruling affirming Bazzi would affect a 1-year back defense, and that would there need to be an extension of the 1-year back rule in these kind of scenarios. Defendant argued and pushed back, stating that although this limitation could seem harsh, it's in place to prevent fraud in the no-fault system. Lastly, the court was interested in the operation of footnote 17 in the dissenting opinion from the Court of Appeals. Footnote 17 states, as recognized by the Titan Court, MCL 257.520 F1, which is part of the Financial Responsibility Act, does not apply to PIP benefits under the No-Fault Act. Of note, the Financial Responsibility Act was enacted 24 years before the No-Fault Act. Hence, our Supreme Court in Titan discerned the legislature's intended scope and applicability of MCL 257.520 F1 with respect to an act that did not exist when MCL 257.520 F1 was enacted. Defendant addressed this particular point by arguing that this section was not about fraudulent contract formation, but about the benefits available in a valid policy. The Bazzi oral arguments are still available online on the Michigan Supreme Court's website if you have any interest in watching them. You can also read the No Fault Newsline authored by my colleague and partner Renee Townsend, which was sent out the day that Bazzi was argued. The Michigan Supreme Court will be issuing its opinion, and we will absolutely provide an overview and thorough analysis on how the decision impacts Michigan no-fault access once it is decided. So We had an opportunity to discuss Bazzi versus Sentinel, the oral arguments held on January 11, the arguments by counsel, the court's focus, and essentially the effect of Bazzi if it's affirmed or overturned. As I mentioned in the opening here, if Bazzi is overturned, then we will no longer be able to assert the argument that an innocent person allegedly not involved in the fraud is precluded from benefits under the policy. Oftentimes we see this happen if it is, a resident relative seeking benefits under the policy, or, some agent acting on behalf of the insured procured the policy and made misrepresentations so that the individual would be eligible for coverage. In those situations, the insured will say, I had no idea the agent was providing misinformation or providing the information of someone else to get me a reduction on the policy rate. I had nothing to do with that misrepresentation. And Bazzi, if affirmed, will allow us to say that doesn't matter. We were still defrauded into providing you with this rate, with this policy, and we may or may not have even insured you had we known all of the accurate information that was true at the time of the application. So if Bazzi is affirmed, we'll be able to continue those arguments, but of course, if not, then there would be an increase in exposure of claims and a preclusion of asserting that there is no policy at the inception of the case. Changing gears a bit, going to the recent Court of Appeals case regarding agreements to arbitrate. This is Ciotti versus Harris, and I will start by saying that this is an unpublished case, which is not binding, but it absolutely provides us with kind of a framework for how we approach arbitration as they are becoming more and more popular these days in lieu of trial. Especially certain carriers actually have it in their policies that arbitration is mandatory in some situations. The Ciotti case essentially went all the way to the Court of Appeals based on one particular phrase within an agreement to arbitrate, and that is the reasoned award phrase. Ciotti is a third-party case arising out of a motor vehicle accident that occurred in December 2012. It was a rear-end motor vehicle accident, and afterward, plaintiff filed a complaint in the circuit court alleging that defendant Harris operated his vehicle in a negligent manner, and he sought to hold AD Transportation vicariously liable for his injuries. In lieu of a trial, the parties agreed to submit plaintiff's claims against Harris and ADT to binding arbitration. The case was submitted to a 3-person panel consisting of one neutral that the parties agreed upon, Marty Waldman, and 2 other individuals, obviously one selected by plaintiff and one selected by defendant. The extensive agreement to arbitrate had numerous terms, but the key provision that was litigated all the way to the Court of Appeals stated as follows. The decision of a majority of the arbitrators shall be sufficient to support the award. The arbitrator shall render a reasoned award in a writing signed by all arbitrators who concur in the award. After the hearing, the panel rendered a non-unanimous award of $668,500 in plaintiff's favor. The defense attorney protested the award to the neutral, Mr. Waldman, contending that the panel had not issued a, quote, reasoned award, unquote, and asked that the arbitrators reconvene to formulate a reasoned award as required by the parties. Waldman responded that the arbitration panel members spent a considerable amount of time deliberating and discussing the claim presented and declined to issue a written decision. On March 9, 2016, soon after the arbitration, the defendant filed a motion to vacate the arbitration award, alleging that the arbitrators exceeded their powers by failing to issue a reasoned award. Plaintiff's counsel forwarded the copy of defendant's motion to the neutral arbitrator, Mr. Waldman. He suggested that an amended award be issued so that they could essentially lay this to rest. Defendants nevertheless objected to this, asserting that in light of their motion, the panel was without jurisdiction or authority to modify or amend or explain the award. The next day, on March 11, 2016, the plaintiff filed a motion to enforce the award and impose costs for plaintiff's refusal to abide by the terms of the arbitration. The parties appeared before the court and essentially argued their respective positions. Defendant harped on the fact that the award itself was not a reasoned award because there was no explanation to justify or substantiate the amount that was issued, and therefore they requested that they be vacated. Defendants also argued that the amended award was invalid because the panel lacked jurisdiction to issue an amended award, and it was not itself a reasoned award because it contained, quote, superficial discussions of the majority's impression of the evidence without specific application of third-party no-fault damages and concepts. So essentially what the arbitration panel did was explain the flaws in the evidence in their decision to issue the award and didn't do a thorough McCormick analysis going through why they got to this point. So following argument, the trial court denied defendant's motion to set aside the amended arbitration award. The trial court concluded that despite the, quote, hiccup, the arbitration panel had ultimately issued a reasoned award as required by the parties' agreement. The court also declined the defendant's request to hold the amended award invalid as a result of plaintiff's inadvertent disclosure of the high-low agreement after the arbitration had concluded. The fact that they received a high-low in and of itself was immaterial because the figure had already been decided upon. Now, many of you are probably already familiar with how arbitration works, and if so, then you will likely encounter issues where there's discussions about whether or not a agreement to arbitrate or an arbitration award can be deemed void or vacated. A trial court may vacate an arbitration award on various grounds listed in MCL 691-1703 for the following reasons. First, it has to be by motion, and on motion of the court by a party to an arbitration proceeding, the court can vacate an award made in the arbitration proceeding if any of the following apply. The award was procured by corruption, fraud, or undue means, or if there's any of the following: evident partiality by an arbitrator appointed as a neutral, corruption by an arbitrator, or misconduct by an arbitrator prejudicing the rights of the party to the arbitration proceeding. Essentially, the defendant in Ciotti argued that by not issuing a lengthy written opinion applying a third-party threshold analysis to the case, that somehow that amounted to an abuse by the arbitrators or corruption by the arbitrators or misconduct that warranted vacating the arbitration award in its entirety. Now, on appeal, the Court of Appeals went through a lengthy analysis of what exactly constitutes a reasoned award. And while there were no Michigan published cases that relied upon this point, there were cases unpublished that provided very clear guidance as to what a reasoned award should be. Specifically, the court relied upon MEHL versus Fifth Third Bank, docket number 278977. If you want that citation, I can give that to you after this podcast or contact me. But the court indicated in MEL that it is an award that on its face sufficiently explains the basis for the arbitrator's decision and reasoning, but formal findings of fact and conclusions of law are rarely not required. The court in Mel found it sufficient that the arbitrator indicated that he considered all testimony, exhibits, and post-hearing submissions, and explained that the case came down to credibility and that the plaintiff's evidence was insufficient to meet the agreed-on, clear and convincing standard of proof. So although the Michigan courts have yet to adopt a definition of a reasoned award in that context, the Court of Appeals in this case was particularly impressed with the fact that the arbitrators did find formal findings of fact and sufficiently explain the basis for the decision. They did not have to issue a conclusion of law. They did not have to issue specific findings of fact, But what they issued, which was the explanation of the evidentiary flaws in the case, was sufficient to deem it a reasoned award. Ultimately, the Court of Appeals found that there were no grounds to vacate the arbitration award in the Ciotti case. And essentially, the takeaway from Ciotti is you want to be very specific in your agreement to arbitrate if you are expecting some sort of thorough finding of fact and conclusions of law by the arbitrators. Otherwise, the phrases that are utilized in an agreement to arbitrate can be interpreted a plethora of ways by the arbitrators. And you don't want to be caught in a litigation battle after you've already gone through arbitration, trying to vacate an award, trying to get the Court of Appeals to take your case to determine whether or not, the trial court made a correct or incorrect decision, and whether, or essentially what you're going to do is just tie yourself up in litigation for at least a year or so after an arbitration, just by not clarifying the terms of your agreement to arbitrate. If you want a reasoned award and you want that to mean a full, complete analysis of the evidence to the law and the facts to the law and an application of that, then spell that out in your agreement to arbitrate. So the lesson from Ciotti is to thoroughly comb through your agreements to arbitrate and spell out exactly what you mean or what your counsel means by the phrases contained within the agreement. Now, the last topic for discussion for today is a new published case that came out that is affecting a lot of these cases involving veterans and veterans receiving benefits through the VA. And that's the case of Batts versus Titan Insurance. Essentially, the holding in Titan, or Batts versus Titan, was that VA benefits are outside the scope of MCL 500.3109. And a lot of us that do first-party work are often, the first thing that you do when you get a claim is you check to see if there's a coordination of benefits clauses. Is this a coordinated policy? Is there a set-off of some sort? Is there a workers' compensation set-off? Did Blue Cross make any payments? Did Medicare make any payments? All of that mitigates your exposure in a case or alerts you to the fact that you could be on the hook down the line for even more benefits than you believe the case to be worth or valued at upon receipt of a new claim. And all of the adjustment of a coordination benefit stems from the statute itself, MCL 500.3109. And obviously that portion provides for the coordination of benefits, but what is typically litigated and what was litigated in the Batts versus Titan case was that an insurer providing personal protection insurance benefits under MCL 500.3109 at appropriately reduced premium rates, deductibles, and exclusions reasonably related to health and accident coverage of the insured. In other words, the provision refers to a coordination of no-fault policies. For example, no-fault policies that are purchased by the insured that coordinate their no-fault and health insurance coverage in exchange for a reduced premium. Now, it gets a little trickier when you look at a lot of these government-offered benefits, because you have the interplay of the No Fault Act, you have the interplay of federal statutes, so you really do need to take a close look at what the benefit is, where the benefit stems from, state or federal statute, and whether there is the argument or availability of a set-off. And Batts versus Titan Insurance Company does provide a very nice analysis of that. I can provide you with more written materials on this if you want to contact me afterward. But essentially, in Batts versus Titan, plaintiff was a military veteran riding his motor scooter and was injured when he was struck by a vehicle that failed to stop at an intersection. The vehicle could not be identified. Plaintiff received various medical treatment through the Veterans Association for his injuries, but he also received medical care from non-VA providers, including a facility called Serenity Personal Care, which was an assisted living facility. The plaintiff did not have a policy of no-fault insurance available to him or in his household. Therefore, he filed a claim for first-party benefits through the Michigan Assigned Claims Plan, which ultimately assigned the claim to Titan Insurance. Defendant Titan refused to pay any of the requested first-party benefits on the ground that plaintiff was entitled to health care benefits through the VA, and therefore the VA was the primary insurer responsible for plaintiff's medical care and medical expenses. After plaintiff filed a complaint seeking PIP benefits from defendant, plaintiff alleged that, of course, defendant had refused to pay any PIP benefits, including medical care, attendant care, replacement services, and transportation benefits. Immediately upon receiving the suit, defendant Titan again reaffirmed its position that it was not responsible for any of those payments because plaintiff was a VA benefit recipient. Ultimately, defendant filed a motion for summary disposition, arguing that as a military veteran, plaintiff had health insurance coverage through the VA, which, like an HMO, required plaintiff to receive medical treatment within the VA system. Consequently, and under the coordination of benefits provision of 3109, defendant was not liable for the cost of any medical treatment received by plaintiff outside of the VA system. Similarly, because benefits through the assigned claims carrier are coordinated and plaintiff had health care coverage through the VA, defendant was not liable for any of plaintiff's medical expenses. Lastly, defendant Titan argued that under the set-off provisions of 3109, defendant was entitled to a set-off against federal benefits to which plaintiff was entitled. In this case, the VA health system could provide the same treatments and services plaintiff received from non-VA providers after his motor vehicle accident. Thus, defendant was not liable for those expenses. Plaintiff responded to defendant's motion for summary and also requested summary disposition on their own position as well. Plaintiff presented a couple interesting arguments. The first argument, plaintiff argued that the VA is not a health insurance company. It is a medical provider of last resort for veterans unless they have a service-connected injury. Federal law, specifically 38 U.S.C. 1729, establishes that the VA is not an insurer because it grants the federal government the right to be reimbursed for the cost of medical care provided to veterans for non-service-related injuries. Second, plaintiff argued that the no-fault provision in cases relied upon by defendant are, in support of its legal position, are inopposite. Specifically, plaintiff did not choose to purchase a coordinated automobile insurance policy that offered reduced health care benefits. Again, because the VA is not a health insurance company, defendant's arguments were meritless. Ultimately, the trial court denied defendant's dispositive motion and held that because the VA did not offer services that plaintiff needed, defendant was liable for those expenses incurred outside of the VA. Subsequently, the trial court granted defendant's motion to stay proceeding pending the court's appellate court decision, as this was kind of an interesting issue that had percolated in the courts for some time. The Supreme Court issued a very in-depth analysis of the interplay between the statute providing for VA benefits and MCL 3109, which allows for a set-off of sorts if available to the insurance carrier. The court looked to a plethora of case law by the Supreme Court and stated that the history of 3109 indicates that the legislature's intent was to require a set-off of government benefits that duplicate the no-fault benefits payable because of the accident and are thereby reduced to contain the cost of basic insurance. The federal statute providing for VA benefits, USC 1729, negates any argument that the VA was liable and primarily responsible to provide medical benefits to plaintiff for his non-service-related motor vehicle accident injuries. In other words, there was no duplication of governmental benefits related to plaintiff's medical care. The United States is entitled to reimbursement for all medical services provided to the plaintiff for accident-related injuries. Thus, defendant Titan is not entitled to a set-off for the medical services provided to the plaintiff by the VA for accident-related injuries. The health care benefits plaintiff received from the VA were outside the scope of MCL 3109. Moreover, because defendant was the primary insurer responsible for plaintiff's medical expenses for injuries sustained in an accident, Plaintiff was not required to solely seek medical care and services through the VA system. It's very important because the court is essentially saying that just because you are eligible to receive VA benefits doesn't mean that your accident-related treatment is limited to those available to you through the VA. You can essentially treat wherever you want, and your auto carrier cannot control which facility you're going to go treat with, and you're certainly not limited to your pre-accident facilities. So in summary, the court held that defendant, as the assigned claims insurer, was required under the No Fault Act to promptly pay plaintiff's PIP benefits, and defendant's reasons for refusing to pay them were unreasonable. Therefore, the court determined that plaintiff's summary disposition should have been granted. Essentially, the court not only affirmed the decision of the trial court, but determined that there should have been an entry of an order granting summary disposition in plaintiff's favor. So essentially, the law that comes out of this Batts versus Titan insurance is that a no-fault insurance is not entitled to set off for VA benefits. And more importantly, that just because an individual has VA treatment available to them and facilities that they were treating with beforehand, they are certainly not limited or required to continue that course of treatment and essentially bill it to the VA. Now, those three cases or those three issues are the hot topics for the month. If you have any questions, please do not hesitate to contact me. My contact information is located on the slides. Again, Javon David from Secrest, Wardle's Troy office. We'll continue to monitor the Court of Appeals and the legislature, as well as the Michigan Supreme Court, and keep you posted and advised of updated law for the month of January. Stay tuned for our February 2018 topic, and of course, keep a lookout for our newsletters and updates in the law that you can contact us for or view on LinkedIn. Thank you for your time.